morning, everyone, and thank you for joining us today. My name is Michaela Vrazdova, and I'm a senior attorney at Scott Legal PC. Today, we are going to spend some time and talk about the National Interest Waiver green card, also known as NIW. This is a very underutilized category and one that we have started to see more and more people use to get a green card, and in particular in the entrepreneur category. So a few things before we get started. So Scott Legal is a full-service immigration law firm, and we process a number of different types of visas, including visas in the NIW category. We will continue to have this webinar series, and we'll have at least 2 webinars a month on different visa and green card topics. At the end of this webinar, we'll send you out a few things. So we'll send you the PowerPoint we'll be using during this webinar. We will send you an NIW comprehensive visa guide, and we will also send you a link where you can sign up for additional future webinars. Regarding panelists today, we are lucky to have Ian Scott, who is the founder of Scott Legal and has a vast experience in the NIW area. As I said, my name is Michaela Vrazdova, and I'm associate at the firm, and I will be moderating today's webinar. So if you have any question as we go through the presentation, please feel free to put the question in the chat box or in the Q&A box, and we will get to all questions at the end of the presentation. And finally, this webinar is being recorded and will be made available on our YouTube channel. And we also do encourage you to hit the notification button on our YouTube channel, as we often post new videos on different immigration topics. Perfect. So why don't we get started? Ian, so could you go over the basic requirements for the NIW? How can someone qualify for the NIW?
Perfect. No, thank you very much, Michaela. And I think with the National Interest Waiver, I think the very first thing to think about with the National Interest Waiver is whether you qualify just under the threshold requirement. So when I say the threshold requirement, the National Interest Waiver is within, it's a green card, and what it is within the category of EB-2. The employment-based green card categories are listed from EB-1 through EB-5, and this falls under the EB-2 category. Now, the EB-2 category is shared with a company sponsoring you for a green card under a professional category. So EB-2 is broken out into National Interest Waiver, and then it's broken out into company sponsoring you for a green card. Now, in order to even consider moving into the EB-2 category, there are threshold requirements that you have to meet. So before we even start talking about the basics of the National Interest Waiver, there are threshold requirements that have to be met. And those are that you have to have either, and these are all either or, right? So either an advanced degree, and an advanced degree is a master's degree or higher, so a PhD or a master's degree, and that can be from, it has to be equivalent to the US master's degree, but it can be from any country. So it doesn't have to be a master's in the US, but a master's degree or higher, or an equivalent. An equivalent is described as a bachelor's degree plus 5 years of progressive work experience, right? So now you can qualify under this with an advanced degree, master's degree or higher, or a bachelor's degree plus 5 years experience, or, and again, keep in mind, these are all or, right? Or if an individual, like, so let's say, for example, an individual just has a high school diploma, they can still qualify under this category, the threshold section, if they have what's called exceptional ability. And exceptional ability is not to be confused with extraordinary ability under the EB-1 category. But exceptional ability, really, there are 7 criteria that are listed on the slide. And if you meet 3 of those criteria, then you can qualify to enter the EB-2 category. Now, we get an enormous amount of calls with respect to National Interest Waiver, where people look at these threshold requirements and they say, hey, I have an advanced degree, or hey, I meet 3 of these 7 requirements, I'm eligible for NIW, but that's incorrect. That's just before we even start looking at the National Interest Waiver requirements, you have to meet these threshold requirements. So an individual, for example, with a high school diploma that doesn't meet any of these, or doesn't meet 3 of the exceptional ability criteria that are listed there, would not be able to apply for a national interest waiver. Like, so they wouldn't be able to even consider moving towards the moving towards the 3 requirements related to national interest waiver. Similarly, an individual with just a bachelor's degree, and if that person wasn't able to meet at least 3 of these 7 requirements, because they have a bachelor's degree, but not the bachelor's plus 5 years experience, then they wouldn't be eligible to even start the national interest waiver process. So those are, kind of threshold considerations. So now we move to the actual requirements related to national interest waiver petitions, and these are all based on a case that was sent to USCIS for adjudication, and then the case was denied. So USCIS said, we don't believe this qualifies under the national interest waiver criteria. And then it was appealed. The person said, well, we disagree with you, USCIS, and it was appealed. And then the appeals board wrote a precedent decision. It's called Matter of Danisar, and wrote a precedent decision and said, well, they too believe that this person was eligible for national interest waiver. And then they set out the criteria or the requirements for somebody to meet the national interest waiver standard. And what those are, and we'll talk about these in more detail, but at a high level, what these are is the first thing you do whenever we're even thinking of a national interest waiver petition. The very first thing that we ask the individual to do is to describe to us what you plan to come to the United States to do, and we describe that as their endeavor. So what is your proposed endeavor? And so the first standard is that the proposed endeavor has to have both substantial merit and national importance. So that's and substantial merit and national importance is really getting at, when we're thinking of an endeavor, like let's take some easy ones. Let's say someone was coming to the United States to develop a vaccine that caused illness and death in people. That's obviously something that would be in the national interest. But similarly, even when we look at this in the context of entrepreneurs, we can sometimes say something like, let's say someone is coming to the U.S. to start an endeavor, and they are going to create a large number of jobs. So, and in particular, if those jobs are in geographical locations where there's high unemployment, then that too could be an endeavor where it meets the substantial merit and national importance criteria. Now, the second requirement in the Danisar and in the national interest waiver is that you are well positioned to advance the proposed endeavor. Now, when we think of this, it sounds easy, right? Like, the person is well positioned to do it, so maybe they have the proper education or the proper work experience, et cetera. But this particular requirement is actually one of the more difficult ones, because the first requirement is relatively easy to meet because you have a lot of latitude with respect to how it is you define it. So you might be able to say that the proposed endeavor is very grand, because the proposed endeavor has nothing to do necessarily at this point with the individual. It's just describing what it is that the individual plans on doing. So it could be something very grand. So you could say that, we propose that the proposed endeavor is that the person is going to start a company and hire, 10,000 people. Right, that could be the proposed endeavor. Now, clearly, that kind of company that create 10,000 jobs, that there's no question that would be, have substantial merit and be nationally important. But then the question, when we move to prong 2, the question of, is the person well positioned to advance the endeavor? It has to be the endeavor that you talked about above, right? It's not just any endeavor. It's not the endeavor of creating 10 jobs or 20 jobs or 30 jobs. It has to be the endeavor that we talked about before. So we are going to look at the education of the person. We're going to look at their work experience. But a very, very big thing here is looking at track record. So has the person created employment to the extent that they're talking about in prong 1 before, right? We may look here to see that the company is capitalized. We may look to see that if the company already exists, and what are the revenues of the company? Like, how far along are they towards the goal, right? Because someone could, for example, be in the United States on an EB-2, they could have an existing entity, and they apply for a national interest waiver saying that they're going to create a bunch of jobs. And then we would look at, how's the business doing? What contracts does the business have now? And how are things moving along? So that's the second criterion. Then the third criteria is that the government has, remember at the beginning I said that this category is EB-2, and it's shared with the category of a company sponsoring someone for a green card. Now, when a company sponsors someone for a green card, the company has to go through a labor certification process, and that labor certification process is really something that shows that they can't hire a qualified U.S. person. So they have to go through an extensive exercise extensive exercise of showing that they can't hire a qualified U.S. person. And Congress has said that that's in the national interest because it's protecting U.S. jobs. So the third prong is really getting at showing that despite the fact that Congress has already said that it's in the national interest to protect jobs, that we should still give this person a green card. And that's why it's called a waiver, because that's where the waiver part of it is coming, because it's waiving this labor certification, right? It's waiving this exploring and testing the labor market to make sure that you can't find a qualified U.S. worker, and that is where the waiver comes from. So on balance, we're looking at that, but practically speaking, even though the case is very clear that there are 3 requirements, practically speaking, there are really 2, because it'd be hard to imagine a case that meets prong 1 and prong 2 and not prong 3, because a lot of the time when we're talking about why on balance the person should get a green card, even though we're not going through the labor certification, we're often pointing to the same things we talked about in prong 1 and prong 2. Prong 2, we're saying that the person is special. They're going to be able to advance this because they're great. They have, great work experience, great education. And then prong 1, we're saying that the other reason that the person shouldn't have to go through the labor certification is because what they're coming here to do is really important. Right. So I think that I think often those are the same arguments. And then sometimes we will actually throw in as well, to the extent that we have anything relevant with respect to some of the EB-1A criteria, we'll utilize those in the description as well, that as to why this person meets the criteria under prong 3.
And Ian, can you share an example of an NIW applicant that met the prong 1 and prong 2, some like real life example?
Sure, absolutely. So one example that I really like to use and is an example of an individual. So this was another case that the applicant applied for the and we may have a slide on this. Just check, do we have a slide later on? Because I can actually use it as we just I can actually use it. I think it's no, is it one more maybe? Yes, perfect. Okay, so this is a great example. Now, this was an actual case. So this was a case where, again, the individual applied for a national interest waiver, and they were denied. And it was an entrepreneur, and it was an individual who's starting a small consulting company where the individual would provide services to U.S. vets that were returning to the U.S. and help them reintegrate into society. Now, this was denied, and then they appealed, and then the appeals board wrote an opinion applying DANISAR and said that, well, no, we disagree with you, USCIS. We think this is, we do think this is an actual case. Now, in terms of, and we walk through each of the different criteria, if we look at substantial merit and national importance, the applicant, they looked at a bunch of news articles and documents that the government had published that said that this is important to the government. It's important that the government treats the veterans correctly and helps them reintegrate into society. And there's documentation showing their difficulties in their reintegration into society and the benefits of having them reintegrate into society. They had experts as well that wrote some letters that talked about this. And the appeals board said that they believe it was there was substantial merit and national importance. When they looked at the person being well positioned to advance the endeavor, they looked at things that, like, they said the person has a good business plan, the person had very, very relevant experience, and the experience kind of showed that he'd been able to successfully deliver these types of services to others in the past. They said that the company was properly capitalized, like it was again a small consulting company, but it was properly capitalized, and concluded that he met that criteria. And then on the third, what this opinion talked about is, because the person was a self-employed entrepreneur, it was impractical to apply the standard of whether or not the labor certification should apply, because an individual who's a sole entrepreneur is not eligible to apply for the labor certification. And that's often an argument that we use for entrepreneurs, in addition to pointing to the merits in prong 1 and prong 2. So this is a great example, and it's a case that we often cite to, in particular when we're doing NIWs for entrepreneurs. And the one thing that's very interesting in this case, and I've read it multiple times, is that the case mentions a number of different times that the company was a small consulting company. So this person was not saying that this company was going to grow into, this vast, grand enterprise. It was a small consulting company, and that was still eligible for a national interest waiver, because the government said that even though it was small, the services that they were offering were important, that they felt those services that they were offering were important to the U.S. government, and so it met the national interest waiver criteria.
Perfect. So let's go back. Let's go back and discuss, how the NIW can be used for entrepreneurs.
Perfect. So this is one of the big changes in DANISAR, because before DANISAR the standard was a lot more difficult, and and part of the reason it was a lot more difficult is because of partly what I just mentioned, that the endeavor had to be grand and geographically grand. So it was interpreted, the case that dealt with national interest waiver before this was interpreted that the effect of the endeavor had to really be national in scope. So hit a number of different states, etc. But DANISAR made it clear that you could just have an impact in one state. And in particular, an argument that we make if we're making an argument related to employment, if we can argue that the jobs that are being created are for people in underserved areas or people who've had a difficult time finding jobs in the past, that is going to be very beneficial, because there's lots of documentation that shows that the government feels that that's beneficial and in the national interest. So there are lots of different things you can, argue. We have one case where the person is focused on providing access to in an industry which is typically underrepresented by the groups that the person is as I think minority groups and gender, a particular industry that's underrepresented, and her firm is focusing on providing more opportunities to those groups, and that could make a great national interest waiver case. So the second bullet point here we talked about, it's really the third prong of DANISAR, where we say that, well, the person's self-employed, so they're not eligible anywhere anyway. And then DANISAR does have some language that that talks about the forward-looking nature of these petitions, right? So they are looking at, what's going to happen in the future, but there is language that says that, ultimately the endeavor doesn't have to succeed to be able to get the national interest waiver. And that is helpful. I think especially helpful because I don't necessarily know if it's that helpful for filing the petition and getting it approved, because I think that USCIS does apply a standard where they definitely want to see some progress, or definitely want to see that the endeavor is going to be successful. However, I think that it provides some cover for people when they are applying for citizenship later, right? Because you could start a national interest waiver endeavor, it could flop in 3 months after you get your green card. And if without that kind of language in the AO opinion, people might be a bit worried that when they say, for example, apply for citizenship, that the government comes back and says that you got the green card and didn't do what you said you were going to do. But they have some protection here in terms of what the Office of Appeal said. So.
And Ian, do entrepreneurs need like an established company that has been operating here for, a couple of years, or can they apply with a startup?
Yeah, it's a great question. Yes, and they can definitely apply for with a startup. There's no question, as long as they meet the criteria, they can apply with the startup. I think that if they do have an existing entity and they're using job creation as the as the mechanism for the national importance, then definitely having employees already and having a successful enterprise, like tax returns that show successful enterprise, is going to be useful. But definitely you could do a startup. You could do a business plan. Like, let's say that you're basing the national importance on economic benefit. You could do a business plan, and you'd have an economist come and look at the business plan and write a report that says this is the impact, on the economy and on the nation with respect to the jobs that this person's claiming that they're going to create. So that's definitely, that's definitely possible. And then I think that if you don't have much yet, then prong 2 is going to be more difficult, right? Because prong 2, they're going to look to say, well, has this person been able to do this before, right? Whereas if you already have a lot of this in place, so let's say you already have 25 employees, and then prong 2, you're going to utilize what you actually have rather than saying that, and saying that what you might have. Even with 25 employees, you still, if you're relying just on economic benefit, even with 25 employees, you're still going to develop a business plan, but I think that if you can point to employees, that's always going to be more beneficial, I think, than not being able to point to employees. So.
Perfect. So let's go over the timing and some other considerations when moving from a non-immigrant visa, such as, for example, an E2 to an NIW.
Yeah, absolutely. So one great thing that happened with national interest waiver petitions this year, or was it maybe the end of it was this year, 2023, was that started last year, but now it's for everyone, is that they allow premium processing now. So you can pay the government $2,500 and they will adjudicate the petition within 45 days, which is great. Now, the one thing to keep in mind with respect to timing, though, is this falls under the EB-2 category, and right now the EB-2 category is delayed for all countries. So there is about a year wait or something like that, and you aren't able to file the I-485, the adjustment of status petition, if you're in the US concurrently. So that's something you always have to keep your eye on, the visa bulletin. I think that with that, you have to kind of always, like, if you're on, like, for example, use E2 as an example, but any non-immigrant visa, you have to keep in mind that you do have to maintain the underlying status. Like, filing an I-140 petition on its own is not going to give you any ability to stay in the United States. The only time you get to stay in the United States after you filed a petition like that is if you can file the I-485 at the same time. And right now you can't do that because it's backlogged. So you do have to kind of, if you're on an E2 or another type of visa, you have to make sure that you are, in status. And that's why sometimes when people apply for the national interest waiver, we would encourage them to apply for it maybe right after you do a renewal, right? So don't do it when you only have 6 months or a year or even a year and a half left for your non-immigrant visa, like an E2 or something like that. You should apply before. In terms of the process, it's going to be an I-140 petition with all of the proof that you have related to the 3 elements that we talked about and the threshold issues. And then we talked about, ability to file an I-485. And the 2 ways to apply for a green card are, if you're in the United States, you can file a I-485 adjustment of status petition. And if you're not, then you can file a consular processing. And sometimes people file consular processing anyway, because if they're in the United States and they need to travel back and forth, then they elect that, because when you file an I-485, if you could file it now and you filed I-485, it's going to take maybe 8 months, maybe even to a year to get work authorization. And if that's, if it takes 8 months to a year to get work authorization, you can't travel during that period of time. So.
And what about family members? What family members can apply for the green card?
Yeah, absolutely. So the family members can join in the green card process. So when whatever benefit the primary applicant gets, the family member, spouse, and children under 21 will all get that benefit. So if the primary, he or she files the I-485, spouse and children can file the I-485. They can also file the, if he or she files the I-485 and the work authorization, travel authorization, spouse and children under 21 can all file those documents as well.
Perfect. Yeah, so let's go over the 2022 updated guidelines for STEM and entrepreneurs.
Yeah, so what was great is great with respect to National Interest Waiver is that it's a focus of the government, and the government wants more people to enter the country that meet this standard. And they published some guidance with respect to people on STEM, so science, technology, engineering, and math, STEM degrees, and basically said that when to examiners, they said, when you're looking at these, if people have a STEM degree, then that's actually really favorable. It's not going to be determinative, but it's really favorable that maybe they meet the criteria, because the government has signaled that we actually want more people in these fields. So that's, so that lends itself to the national importance argument, right? So and then I think that with entrepreneurs, you can actually like in terms of other things that point to the substantial merit and national importance is, the individual getting, like, let's say their business idea gets significant media attention, or gets awards, or gets kind of funding from venture capitalists. Like all of that, it kind of shows two things, right? The interest, it shows the interest, but also the fact that you can argue that if someone's investing, if venture capital funds investing in that particular business, that's going to be beneficial for the economy, because it's going to bolster as well your ability to say that your endeavor is grand, and then also it's going to bolster your ability to say that you're well positioned to advance the endeavor because you have the funding to do it. So it's definitely that's going to be helpful. And then we talked about some of these things that we focus on when we're looking at whether the person's well positioned, but we're looking to look at their degrees, their experience. We're going to look at how much investment they have. Like if someone is in an incubator or something like that, that's going to be great for the petition as well, and great for that particular well positioned. If they've received different grants, it's going to be similar to the reason as to why they are well positioned if they received other funding. I think government grants in particular, or you can point that back to say that if someone is getting a government grant, then that branch of government also feels that what they're doing is very important. So that could link a lot more into prong number one as well. To the extent that the person has some type of intellectual property, that's often going to be useful as well. So a number of factors that we use to pull together the applications, and these are definitely not cookie cutter applications. They're applications that are very specialized, highly specialized applications. So.
Perfect. So Ian, what is usually kind of included in an NIW submission, and can you provide like an estimate, like how long does it usually take to kind of put the whole application together?
Sure. So the first thing that we provide proof of is, that the person has met the threshold requirements. So that could be easy, right? That could just be, a master's degree, right? That would be a nice and easy one. The more complicated ones are if you are bachelor's plus 5, because you'd have to submit the bachelor's degree, but then you'd also need letters. We can't just say that the person has 5 years of work experience. You'd need letters from previous employers describing the experience and making sure that it is progressive, like progressive meaning increasing responsibility over time. And then if we are relying on exceptional ability, and always remember, these are all, or if you meet if you have a master's degree, you can stop there and move to the National Interest Waiver, DANISAR criteria. then we would put together the information, we'd gather. So let's say we're saying the person judged the work of others, we would get information related to that. If they had a key role in a critical organization or something like that, we would get information related to that. So provide evidence that they've met 3 of the 7 criteria. In terms of the other evidence that we provide, it's really going to depend on, it's really going to depend on exactly, it's really going to depend on exactly what the endeavor is and exactly what we're looking for related to the specific case. But often we can get information, like you can show that something is of national importance with newspaper articles, academic papers, things that the government publishes. That's going to be really, really important. If the government has published, especially the federal government, has published something that says that we feel this is important, then, cybersecurity, we do a lot of, we did a E2 person that was a cybersecurity expert and then did an NIW for them, and it was approved in 15 days. Those are all going to be important, anything that you can get to point to why this is important. The other big piece here of evidence is we use expert letters, and the expert letters can be an expert talking about why this particular endeavor is important, right? So they can review a business plan and they can review what the actual endeavor is. Because as I said, the very first thing we do with National Interest Waiver petitions is get people to describe what their endeavor is, right? Because that's very important. It cannot be general that like it's, we have to sit down and say, what are you coming to the US to do? It could be that you're coming to take a particular job. It could be that you're starting your own business. It could be that you're coming to invent something, but you have to specifically describe what it is your endeavor is. And then we're going to obviously include information related for prong 2. If the resume, work experience, describing their work experience, we're going to show it. Like if we're showing a track record, like let's say the person had started companies before, we might get some expert letters for that, like people that are familiar, but then also documentation showing that the person has created this company or has created employment before. We're going to, if the business is up and running, we're going to include the contracts that exist, and we're going to include tax returns, et cetera. And then the final piece of evidence I think that we tend to pull together is for prong 3, even though we do point to prong 1 and prong 2, the evidence that we see, but we do sometimes look at the extraordinary ability criteria under the EB-1 category. So if someone has publications or things like that, we would look at that information and we would include that for prong 3.
And for the expert letters, how many,
Sure.
you usually recommend to submit, and should these be from people who kind of personally know the applicant or kind of like independent experts?
Yeah, so the expert opinion letters, usually 4 to 6, I think is good. And, I think that the less the person knows you, the better, because the more outside of your circle that they are, the better. Like, so if you get an expert letter from someone who works in the same, like, let's say you're doing an NIW to work at a particular company, and someone who works in the particular company, then that's not going to be nearly as good as an expert letter that comes from, an independent party. Like, for example, when you do the Economist report is a form of an expert letter, and that will often be, or almost always be, someone that doesn't know you at all. They're going to be looking at your documentation and writing the letter based on that.
And what if someone has like previous expert letters from like an O1 petition or, like a different visa petition? Can we kind of reuse those, or would we submit like completely like new ones?
Yeah, we could use them. We could take a look at them and see if they're usable, and then kind of go from there.
Perfect. So we already went over a case study. Perfect. So let's see if we have any questions that came up during presentation. I don't think so. So thank you very much, Ian, for
Excellent.
all the information.
No, my pleasure.
And thank you everyone for joining us today.
Thank you. Thank you very much, Michaela.
Thank
okay,
you.
take care.
Bye.
Bye-bye. Bye.